At trial, when an attorney yells out, "Objection, Judge, privileged," does that mean that the attorney is trying to hide something, keep something from the jury? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is no, that's not what it means. In all likelihood, the defense attorney is now questioning my client who's on the witness stand testifying. It might be an accident case, maybe it's a medical malpractice case, maybe it's a wrongful death case. And now he may say something to the effect of, "Mr. Jones, tell us what you and your attorney spoke about." Objection, Judge. That's privileged. Now, what does that mean? What it means is conversations between the attorney and client are confidential. They're privileged, which means that no matter how much the defense attorney wants to learn what it was that we spoke about, he's not going to find out that information. And what he's trying to do by asking that question, he knows better. He knows that I have no choice but to stand up and object. So now he's trying to show the jury that because I'm claiming that this conversation was confidential, that now we're trying to hide something, when the reality is totally different. Instead, the defense attorney is trying to go on a fishing expedition. And he's using this as a clear tactic to try and show the jury that, hey, look, Oginski and his client don't want to tell you what they talked about. Well, guess what? If now we turn the tables and his witness is on the stand, his client, the doctor in a medical malpractice case, and I say, "Doctor, tell me what it was that you and your attorney spoke about," or better yet, "Doctor, tell me what your attorney told you to say when you talked to him before you got on the witness stand today." That, again, would be objectionable, and he'd have every right to stand up, yell out, "Objection, Judge, that's privileged." Now, is it privileged that he told him what to say? No, we don't know what he said or what he told him. We know he had a conversation, just like the defense attorney knows that I spoke to my client before he got on the witness stand. It's natural. But when the defense attorney turns around to the jury and says, "Did you have a conversation with Mr. Oginski before you got on the witness stand?" You know, it makes it look as if he's guilty of doing something wrong simply because he spoke to me about certain things going on with his case, when nothing could be further from the truth. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases, these accident cases, and these wrongful death cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.